From your words, what I understood that chapter 7 is the best if you can qualify. Can you a little bit tell us more about chapter 7 and who can qualify for that?
Sure. Yeah, that's a good. So chapter 7 has what's known as the means test for qualification. When I talk about the means test, I typically describe it in kind of a 3-phase analysis, and the analysis is designed to determine whether there is what the Bankruptcy Code describes as a presumption of abuse. The first phase looks at the debtor's income, and if it's below a certain number, what we call the mean income, which is determined by where you live and how many dependents you have, if your income's below that, then the debtor automatically qualifies for Chapter 7. If you make more than the mean, then we go to a second phase. And the second phase looks at the different types of debt that you have. Although it's kind of a complicated formula, and although it greatly simplifies the analysis, a debtor's rewarded in that analysis for the existence of secured debt. So if you have a larger house, then you're likely going to be able to have more income and still qualify for Chapter 7. So the second phase is kind of like the first phase in that it's a number crunching exercise. And if you pass phase 2, then once again, you automatically qualify for Chapter 7. Now, if you don't automatically qualify in either of the first 2 phases, then this presumption of abuse comes into play that takes you to a third phase, which is basically a facts and circumstances analysis. And there can be a variety of reasons that you may be a perfectly legitimate debtor, not abusing the system, and still have a higher level of income than most. So the Bankruptcy Code then provides you the opportunity to explain how your situation is not abusive. I would point out that if the majority of your business debts, maybe you used your personal credit cards to finance your business, then that standard means test doesn't even apply, and there's no immediate presumption of abuse. So that's kind of a general qualification for 7, how that works. It basically boils down to how much money you make and what kinds and how much debt do you have.
Graham, please ask the next question.
Yeah, and thank you, Greg. As we understood, for this Chapter 7, the basic most important criteria are income, means test, and the type of debt. That's very good information. And as you mentioned that Chapter 11 is the best for the business people, business community, and a lot of our business clients would be hearing this. So would you just let us know what are the different rules they have to satisfy to be eligible for this Chapter 11 bankruptcy?
Sure. Most of the requirements for Chapter 11 are found in a couple of sections of the Bankruptcy Code. One of the most common challenges to confirmation of any Chapter 11 plan is the requirement that a class of claims has to accept the plan, which makes sense. You need an acceptance of the plan. Now, generally, a plan will create what we call classes of claims, and this classification is designed to put similarly situated creditors together so that they get similar treatment, and that makes sense from a fairness standpoint. So, then with respect to any impaired class, which means that your plan is altering their rights. Maybe they're receiving less than they're owed. Maybe they're receiving everything they're owed, but they're receiving it over a longer period of time. So with respect to any impaired class, the class as a whole must accept the plan. So what does it mean? Well, it's defined in the Bankruptcy Code that a class accepts the plan if creditors in that class have accepted the plan in at least 2/3 of the amount of debt and 1/2 in number of the allowed claims. A little bit confusing, but basically, you may have $1 million of debt, but if it's held by one person, then you're pretty much going to need to satisfy that one person. So now, if you can't satisfy that requirement, then the rules require that you be able to show that in spite of not meeting these voting thresholds, that the class of creditors will receive at least as much as they would have in a Chapter 7. I mentioned that before. They call that the liquidation test. So if the business were to liquidate, you look at this hypothetical liquidation and see what creditors would get then. They to get at least that much in a Chapter 11 in order to be able to confirm a plan over their objection. Other requirements of Chapter 11 getting a plan confirmed relate to the classification of claims. A commonly litigated issue is whether a class of claims is truly different than another class of claims. For example, you might seek to give preferential treatment in a plan of reorganization to a class of what we call critical vendors, vendors without which you wouldn't be able to operate. They might be unsecured creditors, just like a credit card company, but you want to propose to pay them a higher percentage so that they want to continue to do business with you after the bankruptcy. Now, the credit card companies might not think that's fair because they're saying, we're all unsecured creditors, they shouldn't get more than we get. So that issue gets litigated all the time. But nevertheless, the goal is to come up with a plan that you can get those votes for. And so sometimes preferential treatment to a particular class of creditors is required in order to get their vote. And so you kind of have to thread this needle, so to speak, to try and get a vote with hopes that you don't draw an objection by the creditors. Another commonly litigated rule is what we call the absolute priority rule. If an impaired class of claims has not accepted the plan, then it's still possible to get a plan confirmed if all rules are met. One of those rules is this absolute priority rule. And what that rule says is that with respect to a class of unsecured claims, the holder of any claim or interest that's junior to that claim won't receive anything under the plan. So basically, if you have unsecured creditors here and you have shareholders down here, if you're not going to pay the unsecured creditors everything and they won't accept your plan, then you can't pay the shareholders anything. You may often hear about where in a bankruptcy, the equity interest, shareholders get wiped out. And that typically occurs because to do otherwise would violate this absolute priority rule. If an impaired class of claims doesn't accept the plan, then equity holders, which are lower in priority, can't get anything. And if the plan proposes that they do, then it violates the absolute priority rule and won't get confirmed. Now, one interesting aspect of the new subchapter 5 bankruptcy that was recently passed is that the absolute priority rule does not apply to a subchapter 5 bankruptcy. So subchapter 5 bankruptcies are something that I believe will greatly benefit a lot of small business debtors.
Great.
Greg, in fact, you just mentioned about the subchapter 5. I hear on the news that in this COVID situation, small business see this as a lifeline. So how does that apply to small business compared to the chapter 11 overall?
Sure. No, this subchapter 5, chapter 11 bankruptcy, it's named for basically where it appears in the bankruptcy code, chapter 5. It was passed with what they called the Small Business Reorganization Act. It was signed into law in August of last year, 2019, and it went into effect in February. So it actually started before COVID-19 was really even an issue. As it passed, a subchapter 5 bankruptcy was limited to small businesses with less than about $2.7 million in total debt. But the CARES Act that passed on March the 27th, that's the same act that provided taxpayers with a $1,200 per person stimulus, all these COVID payments. That bill, the CARES Act, increased that cap to $7.5 million. So now small businesses that have debt all the way up to $7.5 million can qualify under subchapter 5. So what's good about a subchapter 5? Well, much like a chapter 13 case for individuals with regular monthly income, subchapter 5 allows a debtor to spread its debt over 3 to 5 years, during which time the debtor is required to devote its projected disposable income to paying creditors. That's a defined term in the bankruptcy code, that projected disposable income. In many cases, this model benefits both debtors by allowing them to spread payments over time and creditors by allowing them to get a meaningful recovery from debtors who might not have money on hand when the case is initially filed. And so unlike a traditional Chapter 11 case where all of the administrative expenses, and administrative expenses means like attorney's fees going through Chapter 11. It means expenses that are incurred during the Chapter 11, like taxes and things like that. In a traditional Chapter 11, those have to be paid at plan confirmation, which is often difficult. Under Subchapter 5, you're allowed to pay them over the life of the plan. Now, those debts aren't discharged until the debtor completes all the payments under the plan, but ultimately, the debtor will get a discharge after the plan has been completed. Now, in order to keep cases moving quickly, which theoretically conserves administrative costs, a Subchapter 5 debtor must normally file their plan of organization within 90 days after entering bankruptcy, and that's a lot quicker than the normal Chapter 11 requirement. Now, the Bankruptcy Code provides that the court can extend that deadline if the need for the extension is attributable to circumstances which the debtor couldn't control or something like that. And in the COVID-19 environment, I would suspect that courts are likely going to liberally grant those kinds of extensions. So a couple other things about this Subchapter 5. One relates to appointment of a trustee. Normally in a normal Chapter 11 case, a trustee is not appointed. You're considered to be what we call a debtor in possession. And a trustee is only appointed for cause, such as committing fraud or gross mismanagement. If something like that happens in a normal case, a trustee comes in and takes control of the debtor's operations, usually not good for a Chapter 11 case. Under a Subchapter 5 case, a trustee is automatically appointed, but the debtor still gets to retain control of their assets and the operations. In the Subchapter 5 context, creditor committees, which are common in traditional Chapter 11 cases, are usually not going to be formed. And that greatly simplifies a Chapter 11 case when you don't have a creditor committee. Although Subchapter 5 trustees have the authority to investigate the debtor's financial affairs, their primary function is to kind of facilitate as a mediator between the debtor and its creditors and trying to come up with a settlement without having to resort to litigation. The hope is that the involvement of an impartial third party may increase the likelihood of a fair and equitable resolution among the debtor and its creditors. And it might be particularly useful for a small business whose creditors are unwilling to make, concessions in light of the current financial crisis. And then finally, what I think is one of the most important provisions and, almost a game changer in the Chapter 11 context, and that's what I mentioned earlier about the absolute priority rule. Importantly, very importantly, the absolute priority rule, a rule that's often provides a very significant challenge to getting a plan confirmed in the traditional Chapter 11 context, does not apply to a Subchapter 5 case, which means that the old owners of the business can remain as the new owners of the business, assuming that they comply with all the other requirements of Subchapter 5. Whereas in a traditional context, they may have had to give up their equity and somebody could swoop in and take over the organization. This absolute priority rule is done away with in a Subchapter 5 case. And so I truly believe that we're going to see Subchapter 5 cases greatly benefit debtors that wouldn't have been able to get a plan confirmed in a traditional Chapter.
Great. Lot of information, Greg.
Thank you, Greg, for the explanation. Thank you.
Yeah.
We were thinking about bankruptcy, and the stigma attached to bankruptcy was the permanent shutdown or shutting down of the business. But now we see that bankruptcy means you can still run your business after filing bankruptcy through availing different provisions. This money is out, like people got income, people got PPP loans and other disaster relief loans. But once it is run out, then people might need to think about, how they can run their business while keeping their operations on. So bankruptcy is a good option while taking this, codes, within the system. So we are so happy and delighted to have you within this panel and learn a lot of stuff. And we wanted to release it to our clients as well as our listeners. they can understand that there are a lot of options available for them to keep their business open, while filing, chapter 7, or chapter, what do you call it? Chapter 7 is complete liquidation. Chapter 11, chapter 5, chapter 13, right? Okay.
It's definitely not for everybody, but it can definitely help in the right situation. So
Right.
Thank you, Greg. It's a common stigma in the public that bankruptcy is not good or bankruptcy will wipe out everything. But there are a lot of options available in the bankruptcy codes that will be helpful to different people, businesses, as situation arises. So it's very good information about, and we deep dive into different codes, the different chapters. So it was very useful information for us as well as our customers.
Right.
Yeah. A lot of people, like you said, a lot of people think you lose everything, and actually the opposite. Bankruptcy is designed to protect what assets you have, and so that's absolutely right.
Thank you so much, to Mitchell and your law firm, and to your efforts and supports One Tax and our clients. Thank you so much, Mitchell, and thanks for joining us.